Good afternoon.
Good afternoon. I neglected to announce before the last case that we're delighted to have been joined by Justice Angela Iannacci, and now we also have with us Justice Molly Reynolds Fitzgerald. It's our pleasure to have them here with us.
Welcome. May it please the Court, my name is Stephen Younger, and I would like to reserve 5 minutes for rebuttal, if that's okay.
Yes.
Plaintiffs are the founders of FanDuel and over 100 of its employees and early-stage investors. Plaintiffs owned a class of shares that were deliberately wiped out by the defendants. Defendants want this court to adopt a choice of law rule that would leave them with no remedy anywhere in the world. All we want is a chance to prove our case in court. So there are two issues. First is whether New York law applies here because of the unique circumstances we have, which involve looting of a company.
Just if I can stop you, they'll have no remedy if the internal affairs doctrine is applied, because shareholders supposedly under Scott's law are not able to sue, or because the corporation, excuse me, the defendants cannot be sued otherwise. They're judgment proof. What is the reason they have no remedy?
Two reasons. One, the First Department got Scottish law wrong. I mean, completely wrong. And I can give you 3 reasons why they got it wrong. First, they accepted the defendant's view of the facts. This is a motion to dismiss.
Were they able to decide it in the way that they did in the posture that the case was before them?
They had the power to decide these issues, but I think it was an improvident exercise of that power for several reasons. One, it's a motion to dismiss. So on a motion to dismiss, you have to accept our version of the facts, not the defense version, which is with their experts' underpinnings.
Yeah, but that's whether or not there's a factual dispute. But before you go on, what was
No,
that
there was a
second,
factual dispute, Your Honor.
Yes,
Yeah.
I want to hear that too. What was the second one? You said there were 2, and then you had the 3 parts to the first. What's the second?
Well, the second reason
Two
is,
reasons why they have no remedies.
Yeah, the second
first was
reason.
the AD got it wrong.
Yeah, so they applied Scott's law wrong, but they should have applied New York law, because this is
that
a
the second
New
reason?
York-centric dispute.
Just to be clear, that's the second reason?
Yeah, that's
That they
actually
have no
probably the
remedy?
first reason.
No,
You're
that's what I'm
right.
saying. What was the second reason? Then you can go back and.
Yeah, the first reason is they should have applied New York law. This is a New
Okay.
York-centric dispute.
Yes.
But the second reason, if you actually get into Scott's law, they
Yes.
got Scott's law horribly wrong. I mean, they determined Scott's law as if your shares are taken from you and you have no remedy under fiduciary duty law. That's not the law in any common law jurisdiction I've ever heard of. And there's several. You asked about facts. The special circumstances test, as our expert shows, is a factual test. That's not something you can decide on a motion to dismiss.
So your point there is that the Scots law generally would not let shareholders sue, but there are exceptions, and at a minimum, your clients fit the exceptions.
Yeah,
Am I getting that?
and the First Department missed one of the most crucial exceptions. It's sort of like derivative law in derivative suits in this country. If you're uniquely harmed, you can bring a suit. Never mentioned in the First Department decision. All they mention is the special circumstances test. But let me first touch on the issue of Greenspun. This case goes back 50 years to a decision of this court by Judge Jones. There, the court rejected the automatic application of the internal affairs doctrine. Virtually everything you're going to hear from the defense would invite you to have a bright line rule where you have to embrace an automatic application
Well,
of that.
isn't that also the restatement position, that that's the default, and then you've got to find a reason why you don't go to the default, which is the state of incorporation's local law?
The restatement section 309 supports our position. It says if a state has a more significant interest, and we say the interest here is deterring bad conduct in this state. That goes back to Judge Cardozo's decision in German American. When someone comes into our state and commits horrible conduct, this
Well,
state takes action.
that would be a big carve-out, because wouldn't that?
No, it's not a big
be the
carve-out.
case of why you want to apply the local law?
No, it's actually very narrow, and if you look at the cases that have applied the exception, first of all, the general rule is internal affairs. We have things like shareholder voting cases. You're going to apply the internal affairs doctrine. But There are only a handful of cases, and there are always cases like this one, where you have looting, where you have people that go outside of the corporate form.
So the difference then is because it's a business tort.
It-
And that's what takes it out of the default that it's the state of incorporation.
That's one reason, and that's what the comment C to Section 309 says.
309,
But-
302, which one? I'm sorry.
No, that's 309.
Sorry, okay.
But it's more than that, Judge Rivera. What you have here is a scheme where the defendants allowed a shareholder to negotiate a deal, bake in terms that help the shareholder, then you have them transferring the shares outside of the company to a company that the same directors controlled. Classic self-dealing situation.
So
So
in
none of
this
this had to do with the internal affairs.
So in this case, would in the very least, this qualify as an exceptional circumstance?
Yeah, that's what we argue, is that this is an exceptional circumstance. We're not arguing that this, I mean, we have a amicus brief from law professors that says, we're saying overrule internal affairs. No way, no how. We believe in the internal affairs doctrine. It's just not this case.
So you don't think it's really, you're not arguing it's New York-centric then? Or maybe you are also.
We are, yeah.
Also. But you're saying, okay, would you agree we start with the presumption of sorts of the internal affairs?
Yeah, New York law, the New York Court of Appeals in Greenspan says it's prima facie. Prima facie is
Okay.
probably a presumption, roughly the same thing.
All right,
Yeah.
so, and then are you asking us to consider not only where the negotiations took place, the factors that are in Greenspan, but also the nature of the conduct that you're alleging?
Yeah, I actually think the nature of the conduct is the most critical. But all of those factors weigh in our favor. The directors voted here. The meetings were held here. The negotiations were here. They even went out and celebrated here. But most important is what's the conduct? The conduct here is abhorrent conduct where somebody had their shares taken from them. And that's where we go back to German American and Judge Cardozo. Judge Cardozo said, when you come into our state and you commit bad conduct, we as New York act. We don't just say you can go incorporate in some rock off in some island somewhere and then say, oh, I'm going to come into New York and take your money. That's just not how...
There's no authority that says the conduct is what dictates, right? I mean, because another factor that you can look at even under an interest analysis is where the company is incorporated, right? So like, there's no authority that says which one of those factors is decisive.
I have to disagree. Yes, the place of incorporation is one factor. In fact, most cases, it's a very heavy factor. But in tort cases, what you look at for conflicts of law is where did the tort take place? And typically, that's where the injury was, so we have New Yorkers hurt here. But we have all the conduct taking place here. None of this conduct took place in Scotland. None of the defendant directors live in Scotland. This was a New York-centric. You have a New York headquartered company. They put the proceeds of the thievery into a New York-based company. Everything took place here in New
Let me
York.
ask you this. Let's assume for one moment, just assume for a moment, that Scott's law indeed would not allow your clients to be able to sue. Just go with me for that for one moment. They bought the shares, knowing that that's the law. Why shouldn't they be held to it?
Well, you can't assume that they bought the shares knowing the law, because that isn't the law. I mean, and by the way, the real point
Well, I
is
think
that the
I think
law
even
of...
the restatement says that, but.
No, but the law of fiduciary duty is almost exactly the same in Scotland as it is here. I mean, if
And
you have to treat...
that, Counselor, is based on the waterfall provision and the special circumstances and the drag-along rights that you're saying were created.
No, what I'm saying, Your Honor, is the substantive body of law, fiduciary duty, is the same, Scotland and New York.
Right,
The only
but-
question is who can sue.
And they breached it, and you have
Yes.
various provisions based on your expert's testimony, which conflicts with the expert testimony that defendant submitted, correct?
Exactly. And on a motion to dismiss under 3211, you can't accept their defendant's expert, particularly when it's fact-laden. And, I mean, just take one example. You're going to hear all this stuff about how this was an arm's-length transaction. Our complaint alleges that it was not an arm's-length transaction.
We don't have to get to
Yeah.
we don't have to get to the merits, right? I mean, this is a question of whether or not the internal affairs doctrine applies as a matter of law. In this case, right? That's all we're doing, or the balancing test, and then you argue, well, under the balancing test, of course, New York law must apply.
Yeah, we actually have
Isn't that the
two-
legal question?
We actually have two arguments. One is the legal question you identified,
Yes.
but then there's also a question of whether they properly threw the case out on a 3211 motion based on Scott's law. So either way, it requires a reversal
Yes,
here.
but if on the first one, yes, that's true. because
Yeah, if
on
you rule the
one we
first way, you don't have to
decide
get to
that
the
it was
second
New York
one.
law,
Yeah.
it's still a reversal. I agree
Right.
with you there, yes.
So maybe I could turn to CPLR 4511, if you may. Here, the First Department resolved this issue without a hearing. And you go back to the Rossman case, 6 times in Rossman, this court talked about a CPLR 4511 hearing. And the result was the application of a rule which is abhorrent to any common law system. To say that a shareholder can't sue when there's a breach of fiduciary duty is just not the law in any
They're
jurisdiction.
a violation of public policy that way, but doesn't the CPLR say may? How do you get to must?
The first way is because this is a motion to dismiss. You cannot resolve so the First Department said there were no special circumstances. Our expert says that's a question of fact under Scottish law. How do you resolve that under this sort of a motion to dismiss setting? You just can't.
Did they
But-
plead any special circumstances?
I'm sorry, Your Honor.
Did they plead any?
Well, to be clear, we pled this case under New York law and under
Right,
Scottish law.
okay.
But we pled the sorts of things that would be special circumstances. 2, for example. 1, the defendants actually took our shares and dealt with them. That is a special circumstance. 2, under the deal documents that they put in front of the court, the directors were agents of the shareholders. And so once you're an agent, you've got a special circumstance, even under the cases that they cite.
That's inferred in your complaint, right?
Yeah, it's inferred in the complaint, and there was enough before the commercial division judge to find that. But
Did the expert point to that and say this is why Scott's law applies?
yes, he did, and he pointed to quite a number of cases. So what you have
So
is
why would you need the hearing? Isn't that just as a matter of law, is the expert correct that, first of all, those are special circumstances, and second of all, that they exist here?
yeah,
Assuming that they existed here, are they
Yeah.
special circumstances?
There are
that come under
3
Scott's law?
reasons why we feel we need a hearing. First, their expert didn't accept our complaint as alleged. I mean, just one example that I mentioned is he says that this was a commercial deal, it was negotiated. We allege the opposite in our complaint. The expert on a motion to dismiss can't have their own set of facts. You have to accept our facts. 2, there are numerous Scottish cases that hold that when you're uniquely harmed, you have a claim, never mentioned in the First Department, not addressed by their expert. And third, you have the special circumstances issue that I mentioned. We believe that this is a pure legal error because this was thrown out on a motion to dismiss. And if you look at the Rossman case has been followed in many cases in the lower court. The Andes case, the Rowitz case, the Duisburg case. All of those cases have said you need a hearing. We asked for a hearing down below. We asked for it again in the First Department. You're going to hear, some what I call cockamamie argument about waiver. But we literally asked the First Department to send this case back so we could have testimony.
So is it your position that this issue can only be resolved in the trial court, in the Supreme Court, and not even entertained at the appellate division?
That's not our point. In fact, this court can take judicial notice. We would never say that the appellate division cannot. It was the circumstances of this case, Judge Canatero. This case was one where there had been no record developed, there was no discovery taken, and there's a third problem in the appellate division taking judicial notice. That is that 4511 talks about taking an appeal and a right to appeal. And we don't have an automatic right of appeal from the appellate division up to this court. Some people remember the days when you almost did, but we believe it was improvident for the appellate division to have decided this in the first instance. But I think our main argument was you just can't do this on a motion to dismiss. You can't throw a case.
To put that
all
point
in.
a little differently, just to make sure I get it, a question of foreign law is proven as a fact, right? You put in witnesses and it's demonstrated. It's a question of fact for the court to determine what foreign law is, right?
Just a slight It's a question of law that's proved like a
Proved by
question of fact.
That's fine.
Yeah.
And on a motion to dismiss, you don't put in all of your proof. You put in enough to create a genuine issue, which is what you did.
Yeah.
And if there's a genuine issue, then the court shouldn't dismiss that.
Well, that's
And
actually.
To ask
the-
a different question, you have more
Yeah.
proof you'd want to put on Scottish law.
Yeah, that's actually the problem with the rule that they would advance.
Right.
You'd have to put in stacks and stacks of evidence as if this was a 3212 motion out of fear that you were going to get thrown out of court before you even had your day in court. And that would be a pernicious result of their application of the rule. Well, if there are no further questions, I'll wait my rebuttal time. Thank you.
It pleases the court, Andrew Rossman for the KKR respondents. I will take the first 15 minutes and my colleagues the rest. I'm going to focus, with the court's permission, on the choice of law question, but I'm here for whatever questions the court has. The Internal Affairs Doctrine has been the bedrock choice of law rule for corporations in New York for 150 years. It's confirmed by 8 decisions of this court. The Greenspun decision did not say that it was overturning the Internal Affairs Doctrine. No court decision has said that Greenspun overturned the Internal Affairs Doctrine.
But Greenspun says that they reject automatic application, right?
Yes, we
Did the
embrace
first
and we embrace
department
that.
make any, did they show their work? Did they give us any analysis of why they decided to use internal affairs? I think they just said it generally applies.
Well, generally applies is exactly the standard that Greenspun applied, not automatically and generally.
But
There's no
Greenspun
daylight between them.
listed various factors.
Greenspun, which applied Massachusetts law, by the way, applied what it said was, in another case, it could imagine looking at factors. The factors that applied were case-specific, including where the trustees met, that happened to be a business trust, and where real property was located, not an issue in this case. There's never been a case, not Greenspun, not any case since Greenspun, that has ever said there must be an express balancing test and that you must show your work. In Zion v. Kurtz, 5 years later, court that had 6 of the same judges that were on the Greenspun court found that the Internal Affairs Doctrine governed in a case where the parties were New York parties on both sides, involved a New York stockbroker and a bank account at Chase Manhattan Bank. The court in that case did not say a balancing test was
But why
necessary.
isn't your adversary correct that it turns on the nature of the claim? Because as the restatement indicates, the Internal Affairs Doctrine is focused on issues related to the structure of the corporation. These are torts.
The fact that it's labeled as a tort is of no consequence at all. The question is it about the internal governance of the corporation? And here, we have something that is in the wheelhouse of the Internal Affairs Doctrine. We have a merger. We have the application of the Articles of Association, the equivalent of the corporate charter, governed by the UK Corporations Act. That is what's complained about.
Counsel, what's the significance of the corporate form? I think you mentioned Greenspun was a trust of some sort, not a corporation.
Correct.
Does that play any decisive role in whether or not you apply the Internal Affairs Doctrine?
I think the Internal Affairs Doctrine applies in both cases, but it particularly, even Greenspun noted that particularly so with respect to corporations. So we're not urging, to be clear, Your Honor, we're not urging that there are no exceptions to the Internal Affairs Doctrine. We're urging the restatement rule, which is that the exceptions are rare and they're well recognized in this court. One time, this court has recognized an exception, and that's in the German-American case, and that's because there was a statutory exception.
So then perhaps I've misread the restatement. I thought the restatement did recognize that a tort claim would fall within the exception.
That's not correct, okay?
Where can you point me in the restatement so that I will no longer make this mistake and say I've made in my interpretation of the restatement?
There is an important difference between, and it's described in the McDermott case, the Delaware Supreme Court case, okay? Corporations can, like people, enter into contracts and commit torts. The question is not, is there an exemption for all torts, okay? Is it external to the rules that govern the corporation as a whole, okay? So if a company's truck runs someone over on 7th Avenue in New York, yes, New York law applies
Okay, where
to
can I
that.
find that in the restatement. That's a very good example, or that's a very good way of thinking about it.
Yeah, so the restatement, Your Honor, says that the exceptions are, besides the statutory exception that I've described in German American coffee, that the second exception is where there's little contact with the state of incorporation and where the contacts are such that essentially all of the business or nearly all of the business and the shareholders are in the forum state. So you have to show two things, absent a statute, which doesn't apply here. No contact with law of incorporation, here's Scotland. That's clearly not the case, and I'll get back to why the First Department noticed that in their opinion, did their work, okay? Second, that has to be such presence, that's the phrase in Greenspun, such presence in the forum state as to override the interest of the law of incorporation. So if you had a circumstance where the only connection was you had a piece of paper filed in a far-flung jurisdiction, that would be one case. That's not our case. This is a company founded in Scotland by Scottish founders under the UK Corporations Act. And what the First Department found, which is critical here, is that the directors who decided to take their positions based on an understanding that it was Scottish law, they were advised in the boardroom during this merger that Scottish law applied to this transaction. Okay? You cannot have two different jurisdictions apply. There's one transaction.
What aspect of the merger occurs in Scotland?
What aspect of the merger occurs in Scotland?
Yes.
Well, you have the merger of, here it's an Irish.
Did they negotiate any terms? Did they sign any documents?
They were advised by Scottish counsel, okay? And you
In
had
Scotland.
corporations. Yes,
Scotland.
neither of the corporations is a New York corporation, okay? They were advised by Scottish counsel. They had lawyers who were, and advisors who were outside of New York, shareholders outside of New York. The plurality of plaintiffs here are Scottish, okay, not in New York.
So under a balancing analysis, you would fare pretty well.
Even if you were balancing, and I urge the court to look at the Hart case, which is probably the most cited case on internal affairs in all kinds of corporate textbooks, certainly I believe the one I read when I was in law school. The Hart case says that there's a special interest that the law of incorporation has. So even if you looked at it as a balancing test, that's the most important one. And only if you've got a circumstance that's so extreme, like the examples I gave, where there's no other contact with the law of incorporation, that's when you might apply another law. Here, this is a real company that operated in Scotland, had more offices in Scotland than it did in New York, and its connection to New York in terms of business, only 10 or 15% of the revenues in New York. It does its business across the country. Should we say the California law should apply, where California plaintiffs sue, that perhaps South Carolina law should apply if there's South
So this is all in
Carolina
the
law?
record, and that's what shows that the appellate division has provided its reasoning?
The reasoning,
said you were
I
gonna
think
get
it's
to that.
2241 of the record, Your Honor, and there the appellate division specifically observes that the board was advised of Scottish law at the time of the merger. And what's critical here, and the 47 leading corporate law professors who put an amicus brief in on our side of this issue observed, you can only have one set of rules that apply
So if
inter
the
se.
advice was erroneous, if we now look back and said, that's erroneous advice, does that matter at all?
Well, it could be that you have erroneous advice. The critical point is that you can't have competing advice. What the restatement observes is that the reason why you have one law that applies to the corporate governance of a corporation is because you want certainty, you want uniformity, you want predictability ex ante, so that people can organize their affairs. They can decide whether or not to sit on boards. They can decide whether or not
But
to do mergers.
Even if you say that Scott's law applies and that the appellate division was right here, shouldn't plaintiffs been afforded the opportunity to plead a case under Scott's law, considering that this came under a 3211?
I'm glad you asked that question. Plaintiffs did have that opportunity. They filed a petition in Scotland asserting Scott's law. They invoked two sections of the UK Corporation Act. If they believed that Scottish law provided for relief for them under breach of fiduciary duty or other concepts, they had that opportunity. They tactically abandoned that claim.
But we don't-
and
we
2
don't-
years later pursued in New York.
We don't care about that.
Yeah, there's no race
I mean,
judicata
yeah.
effect there.
That's not what I'm urging. That's not what I'm urging. My point is, it is not a circumstance where they had no remedy, or had no claim. Where
Shouldn't
we
they have a remedy? Not whether they had one, shouldn't they have one is the question.
Well, not
In
if-
other words, it's a 3211. Whatever happened in Scotland, and you've got competing versions of what happened in Scotland with the case there, whatever that was, shouldn't they, when it's a 3211, shouldn't they be given the chance to plead it under Scottish law?
And it's a 3211 claim that asserts breach of fiduciary duty.
Right.
And the breach of fiduciary duty claim is governed, that is a core internal affairs claim, the relationship between shareholders and directors, okay? So the first two questions here in this appeal, the very first question is whose law applies? Real question is, what is the legal regime that we apply to answering that question? That's choice of law question, right? So we say it's very straightforward, internal affairs, that requires the application of Scots law. The next question is going to be, okay, what does Scots law say? If Scots law says that shareholders individually do not have a claim for a breach of fiduciary duty, which is what we urge it said, which is
Absent
what
special circumstances.
absent special circumstances. If that's right, okay, then that question means that they don't have a claim, and that's okay. Cases get dismissed.
But what about counsel's argument that they didn't present this like you would a 3212 motion? This was a 3211 motion.
What
didn't-
please,
They raised a sufficient amount of a issue with respect to whether special circumstances are present to allow them to get some sort of hearing and evaluation of that evidence.
well, you heard at podium what they claimed their special circumstances were. Their special circumstances are the relationship between directors and shareholders. Those aren't special. Those are the ordinary relationships that all directors have with all shareholders. Special circumstances are a situation where there's some relationship apart from the status relationship of just being a director and just being a shareholder. So I don't think special circumstances.
Well, that sounds like a good argument, but don't they get the chance to make that to
Well,
Supreme
they
Court?
did. So here's the key, and it was conceded at podium too. In the same way that Mr. Younger said this court could take judicial notice of the question. The First Department is one of every court. That's the language in 4511, every court. First Department could take judicial notice. They had 1,000 pages of submissions on the Scots law issue. 1,000 pages, expert affidavits on both sides. The experts had common ground on this issue. They both agreed that under Scots law, the fiduciary duty is owed to the corporation as a whole, not to individual shareholders, absent special circumstances. They might disagree on the application of that, okay? They agreed on that foundation, and it was within the First Department's right to decide that question as a matter of judicial notice. And what plaintiffs did when they were in front of the First Department, albeit in the alternative, is they said to the First Department, you can decide this. He said, we like a remand, but absent a remand, we'd like it decided in our favor.
In the First Department, did you take the position that if the appellate division decided that Scots law applied, it should go back to the trial court?
I don't believe we did take that position. And my colleagues who are going to address that issue can confirm that, but I do not believe we did take that position, Your Honor. So the question of whether or not the question before the court is the 4511 question, which is, did the First Department have the authority to apply it or not? And does the statute require a hearing? Your Honor observed correctly, it says may. It does not say must. The vast majority of cases courts apply foreign law. We have a very sophisticated court system with a global clientele, if you will, and New York courts are applying foreign law all the time.
Excuse me, can you just clarify the special circumstances? Because you're referring to special circumstances as being general in terms of how the corporation operates, but plaintiff's expert is talking about the way the stocks were valued at nil value, and that was the special circumstance that created this breach of fiduciary duty.
I'm glad you asked that question as well, because it gives me a chance to explain. 90% of the common shares here, the ordinary shares here, were not held by plaintiffs. My clients and Mr. Weiss's clients at Shamrock actually held more common shares than plaintiffs did, all of which got wiped out. Not
The
because
value, I'm not
anybody-
even talking about the value, but you use different criteria to value both corporations, and they're saying that one was a revenue and the other was a beta or something to that effect. Why were two different values used?
Well, the reason why two different values used was because the FanDuel company had no EBITDA. It was a money-losing company. It would be worth zero if valued on the basis of multiple of EBITDA. It was running out of money. 150 bidders were pursued to buy this company at the time, which is when it's been the law.
That was before the Murphy decision.
It was before Murphy, but after Murphy had been argued. So folks had a view about the Murphy decision. At that time, no one was interested in paying for this corporation. If there were a bid, my clients and Mr. Weiss's clients had an enormous financial interest in selling it to a higher bidder. They merged with Paddy Power Betfair because it was the only viable deal. And when Paddy Power Betfair...
Part of that agreement also said that even if there was a different result in Murphy, the value would not change.
Correct, and because they hadn't reached that deal in a term, at the time that they signed the term sheet, then they risked losing the one and only deal that would have kept the company alive. So we
Why,
think
then
that...
Murphy would have never changed the situation.
And
If
just,
Murphy was ruled differently, it just would have kept the same amount of money.
if Murphy were ruled differently,
If Murphy did not come down the way it came down, correct?
yes, I'm following, Your Honor.
Then there was no reason to have any change in the valuation because that's what it was valued at pre-Murphy.
So if I may answer the question, Chief Judge. So the reason why we say, just to explain, the reason why we say it was arm's length with the parties on both sides knowledgeable about the Murphy situation at the time is because $145 million of cash that was injected into the company on the Paddy Power Betfair side of the balance sheet, okay? They were given credit in terms of the value of the new company, the percentage of the new company that they were owned, dollar for dollar based on that cash injection. So it had a real translatable into cash value at arm's length for which my clients and Mr. Weiss's clients gave up an enormous amount of value, and they did that to keep the company alive. And the very last thing I'll say connected to that is they had the right to do this deal in the Articles of Association that they bargained for when they put hundreds of millions of dollars into this company because they had a contractual drag-along and a contractual waterfall preference as preferred shareholders. That's just the outcome of the deal. Thank you, Your Honor.
Thank you.
May it please the court, Jonathan Weiss for the Shamrock respondents. I'm going to touch on CPLR 4511. A hallmark of CPLR 4511 is its flexibility. It affords both appellate courts and trial courts broad discretion to take judicial notice of foreign law. The plaintiff's interpretation of that rule would severely restrict that flexibility. It would impose a categorical requirement that would mandate an evidentiary hearing every time the substance of the foreign law was in dispute. That is manifestly inconsistent with the plain language
But would it only
of the rule.
require it when there's factual dispute? Not when it's truly a question of law that requires no fact-finding, or there's an agreement about the facts amongst the parties?
Well, this is an important point, and Judge Wilson raised it. What happened with the sea change, with the implementation of CPLR 4511 and its predecessor statute, CPA 344A, was to say, we want to codify this change. We are no longer going to deem the determination of foreign law as a fact question. That is a pure question of law. And so the change in the rules codified that.
But 4511 talks about findings, And what here are findings versus conclusions? And I think that's a significant difference here.
The findings that 4511 refers to are the conclusions that the court makes upon taking judicial notice.
But doesn't findings connote some kind of analysis that has to be done? It doesn't say conclusions, it says findings. So, to me, that sort of suggests that there needs to be some exploration of the issues, taking into account both sides, not just one, and then analyzing it and making a conclusion that way. Do you disagree with that?
Well, I would say that the whole premise of this rule change that said, listen, courts can take judicial notice of foreign law, they do not have to prove that as a question of fact. I understand the nuance here, because you normally think of findings as findings of fact, and you have to state the explanation for your findings of fact, and perhaps it's an infelicitous choice of words. But what that requirement is stating is that if you take judicial notice of law, of foreign law, you have to express what in fact you found the law to be. And that's exactly what the court
Well,
did
taking
in
that
the
on
first
face
department.
value, that was my question. There doesn't seem to be a lot of explanation at the appellate division about what it found. It just said, this is what the law requires.
Well, so I grant you that there's not a lengthy explanation of the law, but there is a statement of what it found the law to be, which is in fact, and this is a very important point actually, because my colleague, Mr. Younger, said that there was no record developed on this point. There were, as Mr. Rossman said, over 1,000 pages before the first department on Scots law. That included hundreds of pages of decisional authority. That included multiple affidavits from experts that were impeccably credentialed on both sides.
How much of the oral argument was devoted to this issue?
Well, the first department, the oral argument on the first department really hinged on the internal affairs doctrine. That was the focus of that argument.
Okay.
But the point is that the first department had before it this expansive record. And it wasn't just the record. It wasn't just the affidavits of these impeccably credentialed experts on both sides, but it was argument of the parties. There were dozens of pages of real estate in the briefing devoted to this issue. So it's not as though they didn't have material upon which they could rely.
So, counsel, in the absence of an elaborate explanation from the appellate division about what the basis of that finding was, what are we as a reviewing court, what's our jurisdiction here with respect to, I don't think it's just judicial notice of foreign law. I think it's also an application of the foreign law, which to me, I'm sure you disagree, but that seems like a different question. How are we supposed to review that?
I see my time has expired. May I respond?
Please go ahead,
to
yes.
Thank you. So the answer to that question lies in the plain text of CPLR 4511. If you look at its section, if you look at section 4511B, I'm sorry, 4511D. In considering whether a matter of law should be judicially noticed and in determining the matter of law to be judicially noticed, the court may consider any testimony, document, information, or argument on the subject, whether offered by a party or discovered through its own research. So it's not just that you're taking judicial notice to establish what's the raw material that I'm dealing with here, and I respectfully submit over 1,000 pages of record evidence on Scots law is plenty of raw material to ascertain, but it's also, per 4511D, what is the determination of the matter of law that is to be judicially noticed, the determination of the law. And to do that, you can consider a whole variety of things. That's the flexibility of the statute.
How should we understand that requirement if the party is saying, we want to put in more? We think this record is insufficient. We want further discovery. We may want a hearing.
That is up to the sound discretion of the court. And that was
Is it
the
a
touch.
question of law as to whether or not the record is sufficiently robust to make a decision under D? Would that be a question of law?
So the answer to that question would be, did the First Department abuse this wide latitude of discretion afforded to them by 4511 when they determined an issue of Scott's law on over 1,000 pages of record evidence, dozens of pages of specific briefing, and impeccably credentialed experts on both sides, a retired judge of the highest court in Scotland on the defendant's side and a King's Counsel on the plaintiff's side. These were people whose bona fides were without question, whether it was an abuse of discretion on the part of the First Department with that record before it and that briefing and argument, which is expressly identified, argument
So
may be
They
considered.
never explain why there are no special circumstances here. They say that a shareholder, right, a director may owe a fiduciary duty to a shareholder, special circumstances under Scott law, but such circumstances are present here, and they don't say why.
They do, that is correct, Your Honor. They do not say why, but the affidavits
Yes.
that were in the record
Yes.
go, and I could direct you to it if you'd like, but they go chapter and verse through why it is to the case that on the facts as pled in the complaint, the special circumstances exception doesn't apply. There may have been different views on the part of the experts as a matter of Scott's law, whether or not on the facts of the case that exception applied, but it was well within the power and the discretion of the First Department, having reviewed that record, to make the determination of the law as 4511 provides.
Can I,
Yes,
Chief?
of course.
I know that the information was available to the First Department, but when you say that they reviewed it, we're not really able to ascertain that from this record, right? I mean, because they're not referencing any of it. I understand that they might have very well reviewed the thousands of pages of documents, but there's nothing indicating to us that they did. But I have a separate question. I know that you don't think a hearing was required here, but do you think a hearing is required ever, and under what circumstances?
It is a hearing might be, given the circumstances, in the discretion of the court, something that would be appropriate. Absolutely. Rossman absolutely acknowledges that, but it's not required. And the rule that they're espousing here is that it should be required whenever the substance of foreign law is in dispute. Not that it may, on a case-by-case basis, but it always should be required. That is not what the statute says. That is not what the statute says. The last thing I will say is that if you accepted their rule, it would have profound implications for the efficient administration of the courts of this state. Because what it would require is, and we all know in an increasingly global society, and arguably New York is the center of commerce in the world, we see increasingly matters of foreign law at issue in our courts, particularly in the commercial division. So every time you had an issue of foreign law that was in dispute and was outcome determinative, you're invariably going to have differences of opinion about what that substance of the law is. That's what litigation is about.
Chief, may I? Just, I don't mean to
Yeah,
interrupt you.
I apologize.
Just a quick question. So we're talking about hearings. We're talking about judicial notice of foreign law. But now we have a 3211 motion, correct? And the court must accept the facts as true. What if you have the defendant, who has the burden, and their expert is not accepting the facts as true, which is what plaintiff's expert is alleging? Then what happens with respect to the hearing? Not just in this case, in every case that we have before us.
So that's their argument. But the first
I'm
department
not
was-
arguing, I'm
was-
asking. It's a 3211 motion,
Right.
correct?
Correct. And so our.
I'm not arguing, please.
No, I'm saying that with respect to, so I guess the important thing I just want to distinguish, because it's a very subtle question, I want to answer it properly. So with respect to the determination of law on the part of the first department, that's a pure question of law. So that is not a fact question, even though it's a matter of foreign law. So it's not as though you have to draw all reasonable inferences in favor of the non-moving party with respect to the determination of foreign law. That's a pure legal question. With respect to your point about, well, they did not, the first department didn't accord all reasonably favorable inferences to the facts, or even accept the facts as pled as true.
I said the expert.
The expert did not, I'm sorry. That was something that the first department, after reviewing the extensive affidavits of the experts and looking at the allegations in the complaint, could very well decide for itself as a matter of its discretion, which is perfectly within the right and the province of the court to do.
Thank you.
Thank you.
Good afternoon, Your Honors. Mark Kirsch for the FanDuel entities, and Mr. King, Mr. Nathanson, Mr. Cleland. Your Honors, I join in the arguments my colleagues have made. I want to make a couple of points about the work of the Appellate Division. I think what they found, with looking at the 1,000 pages of the expert affidavits and with all the qualifications on both sides, it's not that the facts plaintiffs pleaded were disputed. It's what those facts may mean, do mean, under Scottish law. That's what the experts were opining on. Scottish law holds this, that that directors don't owe fiduciary duties to shareholders except in certain circumstances. Those are not applicable here. That's what the legal determination was, just as if one was making a determination here. And the Appellate Division had every right to exercise its discretion to make that finding. Now, I'd like to also say, underscore.
When you use the word finding, the manner in which they rendered their decision, are you saying it was sufficient to show that they made a finding in the way that the CPLR requires?
I think that's the inexorable conclusion of what they've done. I think we all have to assume that they, in fact, did read the 1,000 pages, in fact, did do their homework, just as this court would do, just as the Supreme Court would do.
Can you justify that answer in terms of Justice Iannaci's last question? This is a motion to dismiss.
Yep.
It's not a summary judgment motion. So, the answer, your colleague who was just up prior to you, seems to suggest that for purposes of this section, foreign law under 4511, we treat it more like summary judgment than we do a motion to dismiss. Is that your position as well?
I think I'll answer your question directly. I don't think we have to get there. And it's because the Appellate Division, based on the opinions, detailed opinions of two Scottish law experts, nobody disputed that, had a view as to what the facts pleaded, whether those in fact plead violations under Scottish law, as they understand Scottish law. And the determination was it does not plead violations under Scottish law. The Appellate Division was entitled to make that finding. If they can't make that finding, then all it's going to take, if the court announces a rule that they
Should
can't.
they have been given an opportunity to refile, to file a complaint under Scottish law? Asserting it, rather?
Whether it should have been, in effect, dismissed with prejudice or without, Your Honor?
Right.
I think they're entitled to make the finding that it would be futile, and I think that's clearly what they must have done, or they could have said it without prejudice. But this is really important, respectfully, because in the event this court were to announce a rule that all it would take to get to an evidentiary hearing when there's a question of foreign law is somebody styling their claims, not just as, say, breach of contract claims, but as wrongful, other kinds of wrongful conduct, then you'd have an evidentiary hearing every single time. It should be the case, in fact, I believe it is the case, that the appellate division
Well, when you
can-
say evidentiary hearing, it could simply be on paper, right?
It could,
That is, this could have been a summary judgment motion on this record.
sure, but one didn't have to get there
Well,
because
that sort of, it seems to me the question is which rule we should choose, right? One way to look at it is, I think, the way you're putting it, which is somebody's filed a motion to dismiss.
Yep.
To know whether the complaint states a claim, you have to know under what law it states a claim. And so
Correct.
the first thing you would have to determine under your theory is what is the governing law. The court has to make that determination to decide whether to dismiss the complaint. It has to make it on whatever record the parties decide to put in front of it for that purpose. That's one way to look at it, right? That's your way to look at it.
yes, Your Honor, and it comes right back, oh,
And the other way to look at it is the parties, if the parties have put in dispute what foreign law is, that can really only be decided on a motion for summary judgment, not necessarily with a hearing, but with a full record about what foreign law is.
Your Honor, respectfully disagree. 4511 allows for a decision on the law without an evidentiary hearing. Now, there's nothing that stops the appellate division from having such a hearing, but they're not required to. And here, with 1,000 pages of briefing, in effect, and affidavits, they clearly made up their mind that this was enough. And this comes
I
right...
think the point is that there's a lot of real estate between no hearing and a hearing. You know, you could have an assessment of the evidence, you can have their findings outlined and their conclusions and what they drew on to reach those conclusions. And then if we had to review whether it was an abuse of discretion, at least we had the basis for what the conclusions, where the conclusions came from. So it doesn't, I don't think the decision is it a formal hearing or not a formal hearing? Is there a basis under which these conclusions came?
Well, if Your Honor is suggesting that this court might not have enough information about what the appellate division was thinking, is that what you're getting at?
Yeah, I mean, yes.
And so whether or not they have to spell out at a certain level of detail what the reasoning is, Your Honor could decide to do that, of course. But here, with voluminous record, when, you know, you almost want to, it's crushing the amount of information they had. The fact they didn't have a more detailed opinion.
But wouldn't your burden be on the motion to dismiss to show that there is nothing else that is relevant that they're going to find or that they could put forward to reach the decision? That was in part my question before about whether or not you have a robust, sufficient record to reach your determination, which is the way I read 4511, that the judge decides whether or not they have enough in front of them to take judicial notice of something. What you wanted is them to take judicial notice that Scott's law, in this case, on these facts, right, would not allow the plaintiffs to be able to sue.
So they didn't use, I'll agree with you, they didn't use any kind of magic words saying, we have enough information. But given the information we know they did have, and the firmness and the
Well, I'm
finality...
not disagreeing with you. My point is, doesn't that mean that our work is to look at this record and say, yes, there's enough in this record for them to have come to that determination? My point is, the burden was on you all to say there is nothing more to put in this record. And we can look at the record and say, no, they're right. They would have been able to put X, Y, and Z, or they could have explored A, B, and C. It strikes me that that's the question if we're going to go down this road.
Well, the court, of course, would review the entire record. This court would review the entire record, no doubt. But again, the absence of magic words saying we had enough, respectfully, need not be required. And I think it's apparent that they thought they had enough. It would be inconceivable to me that they would have thought, well, maybe we have enough, maybe we don't have enough. We're not going to say, and then we're just going to decide. It's not I don't think that's, for me, wouldn't be a critique that I would find appealing. Now, if I might just say, though, this idea also comes right back to some of the policy concerns that animate the internal affairs doctrine. I don't want to
If I may, before you even get into the policy concerns, because we understand that, I understand your policy concerns, I just want to get back to what was before the court. When you have an affidavit from your expert and says that special circumstances are very limited, and then you have a plaintiff's affidavit, that plaintiff's expert saying, you know, you cited a 1914 case, and plaintiff has a 2001 case and a 2017 case. Plaintiff's expert under Scott's law saying that the question is one of fact in each case. It's not your typical type of situation when you could take judicial notice of statute of limitations, correct?
I hear that, Your Honor, but I don't believe the experts actually disagreed on what Scott's law is.
No, I agree. They didn't disagree, but I think there's a difference here with respect to special circumstances. That's where I am asking you to, there were two cases here, one from 2001 and 2017,
Understood.
talking about special circumstances.
But the appellee's expert and the appellant's expert did not disagree on what the categories of special circumstances may be. They agreed on that. The question was whether the facts that were alleged actually make out those claims. And the appellate division went with appellee's expert. They had all the information, again, really crushing them out, and that's the decision. And the question is whether the appellate division was able to do that from the record, and clearly they thought they could, and I see no reason why not, even in the absence of
And we could
all
look at
magic
that and
words.
say that that was a wrong conclusion, based on the
I'm
record.
sorry, Your Honor?
We could look at that and say that's a wrong conclusion based on the record, because it sounds like you're saying the appellate division didn't exercise any authority to find facts. They looked at the record before them and concluded these are not special, their language,
It's correct.
there are no special circumstances
Your
are
Honor's
not found
bound-
here.
Your Honor's not bound by the opinion, clearly. This court is not. No, we have not argued otherwise. We just are suggesting what the court should do respectfully,
Yes, I understand.
which is affirm. And it may just have just a moment on the Internal Affairs Doctrine?
If you can do it very quickly.
I can't. I'll just say again, how important it is. Imagine the difficulties for directors when they are told by their lawyers, when they're thinking about a fundamental corporate transaction or restructuring to wipe out the equity and the new directors will come in, when they're told, here's the law, but by the way, we don't know this is the law that's actually going to apply in the end to how you did your work. And you know why we can't say that? Because you might get clever plaintiffs who, in addition to just saying breach of contract, might spin out misconduct claims, and then it won't apply. And then we're into some balancing. That if you take that point of view respectfully, then I'll tell you what's going to happen. It's going to deter
But then
you.
that means you're looking for an automatic rule, and I thought
No.
that your side has taken the position, no, it's the default rule, there are rare circumstances when it doesn't apply, and so now the shareholders are left with maybe we're the rare circumstance.
I'm just suggesting respectfully that there should not be competing demands on lawyers, rather on directors, as to what law is going to apply. You should try to minimize that, because otherwise it will deter director service, and clearly you want the best directors to serve possible, whether you're sitting in New York or you're sitting anywhere else.
Thank you.
Legal uncertainty, okay, thank you, Your Honor, appreciate it.
Your Honor, just a few points rebuttal. I think Judge Rivera just summed it up. They don't agree with Greenspun. In fact, the automatic application that Greenspun denied is exactly what they're advocating here. And much of what they're saying is, yeah, there should be an exception, but the exception is only this small. The exception that they advocate, either a statute or almost no contacts with the incorporation state, is nowhere found in Greenspun. It's nowhere found in all the cases that follow Greenspun that Mr. Russman said don't exist. It's just
I mean,
simply
it's a
made up
pretty
at a court.
small exception, right? You got generally, you got rarely, you got, so let me switch though and ask you another question.
Yeah, I agree that it's a very small exception. That's why you don't have to worry about these directors moving out of New York. We've had Greenspun for 50 years, and no directors have said, I can't be a director because of Greenspun.
Okay. Is it your position, I think that's what the other lawyers allege, that you have to have, you require a hearing under 4511 every time there's a question of a difference in substantive law?
No. This is more like a 3211 motion. I mean, a 3212 motion, I'm sorry. We had a 3211 motion, it was turned into a 3212. It's only when there's a genuine material dispute. And we talked about the text. The text of 4511 was barely mentioned. It talks about sufficient information. If you put in, and they talk about these thousands of pages of affidavits, no, most of them are just copies of cases. But
So if we agreed with you, what is it that's going to be the focus of this hearing?
yeah, the focus of the hearing is threefold. One, what are the facts? They're expert, and they say that there weren't fact findings there. No, they grabbed onto the defendant's expert's facts, not ours. They didn't accept our facts, which is what you have to do in a 3211. That's number one. Number two, as was pointed out, our expert says whether you have special circumstances is a question of fact. And that's something you develop at a hearing after you've had discovery. Three, something never mentioned.
Again, what are the facts that you're going to present related to that question
Yeah.
that is not already in the record?
Yeah.
Right? What value comes from the hearing? That's what I'm trying to say.
Two facts in particular go to special circumstances. One,
Yes.
the fact that they were dealing in our shares. Remember, they took our shares from the company that they were in and moved them to another company where they were on both sides of the transaction, same director, classic self-dealing. So that's number one. And then they dealt with our shares. That's a classic special circumstance under Scottish law. But number two, never mentioned in their affidavits, is they appointed the directors as agents under the terms of the offer. That, even their cases, the Hyatt case in Scotland, says that you have special circumstances. I just want to go back to one point which I think has been lost here. We're not arguing with the merger. We like the merger. This is a merger classic, 1 + 1 = more than 2. Why? Because we were on the verge of a gold mine. Sports betting was about to come. What we disagree with is a whole course of conduct where, number one, they appointed one of the common shareholders, KKR, to negotiate the deal in their own self-interest. Two, they then took the shares and moved them to a different company. How is that internal affairs? I mean, I don't know how it's internal affairs if I take my shares, put it into a wholly different company. And then three, they came up with terms that hid their misconduct. So this is not an argument about a merger. This is an argument about how they distributed the shares. Your Honor, you mentioned value. They valued the wrong thing. They valued FanDuel. But that's not what they had to value. They had to value Pandaco. So you took a 40% interest and a 60% interest in Pandaco. That's what we were getting. And by the way, they never valued the huge opportunity of sports betting. There's been a lot of talk here about we're arguing for a hearing in every case. We're not arguing for a hearing in every case. We're only arguing for when there's a factual dispute, of a real, genuine material dispute like you have on 3212. The problem here is we had a 3211 motion, and at the end of the day, what the defendants want is they want to throw us out of court on a conflicts of law rule that just doesn't make any sense.
But just
and
to
which-
understand, since your view is that even under Scott's law, you fit the special exceptions, which means you would have had, I understand the choice here, but you would have had a remedy in Scotland. Yes, because you would have argued, as your, right, as your expert.
We would have argued it for two reasons, Your Honor.
Yes,
For
go ahead.
that, and something never mentioned by the First Department, that we were uniquely harmed. If you're uniquely harmed, you can sue in Scotland. And that's something that the First Department never mentioned, even though it's set out squarely in our affidavits. Well, thank you, Your Honor, and we appreciate the time Your Honor's take.
Thank you.